reacting to the Supreme Court's big ruling against the NCAA.
This is really important to all student athletes, just because it hasn't, no legislation has done this for us ever.
In a 9-0 decision, the highest court backing increased education payments for student athletes, paid internships, postgraduate scholarships, tutoring, computers, and study abroad.
It's open season.
And the time to redefine what it means to be a college athlete. We've come a long way from the not so distant and not so good old days.
5-6 years ago, if you had given a player on campus a stipend, that would have been an egregious violation of NCAA rules. They said doomsday was around the corner because people couldn't afford it. It's going to hurt women's sports. We're going to cancel sports.
In one of the most divided times of our country's history, the NCAA, out of all groups, united both sides. The conservatives who root for free markets and the liberals who champion workers' rights.
A 9-0 ruling is a strong statement, though it's not that rare. According to Supreme Court records, a unanimous decision is more likely than any other outcomes. Since 2000, more than a third of Supreme Court cases ended 9-0. 8-10 and 7-2 judgments make up about another 15%. But this NCAA ruling is noteworthy because it's the first time the highest court weighed in on college sports governance since the 80s. When schools were trying to monetize TV rights.
Traced back to a 1984 Supreme Court decision. The NCAA negotiated broadcast rights with networks, and it had rules that limited the amount of football games each school could have on TV. The Supreme Court ruled this arrangement violated federal antitrust laws by fixing higher prices for fewer televised games. And as a result, universities were free to negotiate individual contracts with cable networks, increasing the number of college football teams on TV. This meant that more teams could reach a larger audience.
Aside from the justice's opinion, which basically screamed, student athletes are valuable, the court documents of this NCAA v. Alston case show that the NCAA is not an organization that likes either the free markets or workers' rights.
Almost impossible, Diane, to have this conversation about fairness and about antitrust laws without also acknowledging that there seems to be different standards for different sports. So it isn't just simply about the overarching conversation in terms of how does this impact players or impact college athletes, but it's also about how the NCAA picks and chooses when to enforce these rules based upon the sports and the profitability, which overall just sort of undergirds this notion that this amateurism that they keep hiding behind is really just BS.
While this judgment is not destroying the college sports overlord, NCAA will keep making the rules. It's inevitable that student athletes won't get exploited excessively for long. To quote what Tulane University's Gabe Feldman told Sports Illustrated,
"It feels like the NCAA is caught between 3 rocks and 4 hard places."
The organization's next battle will be over if, or how, players could get compensated when someone else uses their name, image, and likeness. That will be the subject of another video. Come back, like, and subscribe.
This form essentially says that the athlete consents to follow all the rules, essentially enable the NCAA to use the athlete's name and likeness for all of eternity, for profit or for any reason, and prevented the athlete, him or herself, from ever benefiting from that. And that included that athlete's heirs after they died.